Legal professionals of Reddit would ask the funniest way you've ever seen a lawyer or defendant blow a court case. Story 1. The Biblical Divorce Defense. 25 years of marriage, 8 children, and one man asks spectacular misunderstanding of both family law and theology. Picture the scene, a divorce court, where a middle-aged man stands before a judge, ready to unleash his bulletproof argument against paying alimony. His wife, who spent a quarter century raising their 8 children, 3 still at home, sat quietly while her soon-to-be ex-husband prepared to explain why she deserved nothing. His argument, biblical, his logic, non-existent, his chances about to crater through the floor. "Your Honor," he began, with the confidence of someone who definitely never actually read the Bible, "marriage is a contract. A sacred contract with specific duties." The judge nodded, probably expecting a standard responsibility argument. "Oh, how wrong we all were. My wife," he continued, building steam, "has refused to perform her marital duties. Therefore, this isn't really a marriage anymore." The lawyer representing the wife shifted slightly. The court reporter's fingers hesitated over the keys. Everyone sensed we were approaching dangerous territory. "Could you clarify what duties you were referring to?" the judge asked, though the pained expression suggested she already knew. "Her wifely duties. In the bedroom, she wanted, participate in the creation of more children." The wife's attorney stood. "Your Honor, my client has already borne 8 children. 3 are still minors living at home." She asked, 46 years old. "Exactly," the husband exclaimed, missing the point entirely. "She is still young enough, but she refuses to try for more. She is on birth control." The judge's face was transitioning through expressions like a flipbook of judicial disbelief. "Sir," the judge said slowly, "are you arguing that your wife's decision to not have a 9th child invalidates your marriage? It is in the Bible, 'Be fruitful and multiply.' She is violating God's law. We are in a court of law, not a seminary, but marriage is a religious institution." The man had prepared. Oh, had he prepared? He pulled out printed Bible verses, highlighted and annotated. He had charts showing biblical families with dozens of children. He'd created a PowerPoint presentation titled "Why 8 is Not Enough, a Biblical Analysis." His core argument seemed to be that marriage was essentially a breeding contract, and his wife's failure to produce child number 9 was basically breach of contract. Therefore, no alimony. The wife's attorney didn't even need to argue much. Just pointed out that 1. The wife had spent 25 years as a homemaker. 2. She'd raised 8 children. 3. She had no career or recent work experience. 4. Birth control is legal. 5. This is America, not ancient Mesopotamia. But the husband wasn't done. He explained that his wife's refusal to have more children meant she wasn't truly submitting to her husband as commanded by Scripture. The judge's eye twitching had now become visible from the gallery. "Sir, let me make sure I understand," the judge said. "You believe your wife, who bore you 8 children and raised them while you worked, deserves no financial support because she wanted to have a 9th child at age 46. It is not about the number, it is about the principle. She is supposed to be open to God's plan. God's plan appears to have included 8 children. That seems quite open. But she is actively preventing more, with pills." The judge's face had transcended normal expressions and entered some new realm of judicial exhaustion. Here is where it got truly spectacular. The husband then argued that since his wife wouldn't fulfill her biblical duties, he shouldn't have to fulfill his modern legal duties of alimony. He'd created an entire theological framework where child support was only required if the wife remained permanently pregnant. The judge's ruling was swift and brutal. Not only did she award alimony, but she made specific note of the wife's extraordinary contribution to the marriage through bearing and raising 8 children. She also suggested the husband might benefit from both legal counsel and perhaps a more thorough reading of the actual Bible, which has quite a bit to say about caring for one's family. The husband left court muttering about liberal judges and the war on traditional marriage. His wife left with a fair settlement and probably the first peace she'd had in 25 years. Later, the court clerk said the judge went to her chambers and could be heard laughing for 10 solid minutes. Sometimes the best argument against your case is just letting the other side talk. Story 2. The Hammer Time Chicken Massacre. Educational farms are supposed to teach children about agriculture, sustainability, and where food comes from. They are not supposed to teach children about improvised weapon techniques and psychological trauma. Enter our farm manager, a man who apparently confused humane euthanasia with Viking berserker raid. The setup seemed innocent enough. Elementary school field trip to the district's agricultural education center. Sunny day, excited kids ready to pet goats and learn about vegetables. What could go wrong? Everything. Everything could go wrong. The farm had some sick chickens that needed to be euthanized. This happens. There are procedures, veterinary protocols, humane methods. Our manager chose none of these. Instead, he grabbed a hammer. Not a special euthanasia tool, not a proper implement designed for the purpose. A regular hammer from the toolbox, like he was about to hang pictures, not end lives. The children watched in growing horror as he approached the first chicken, raised the hammer, and, whack, the chicken didn't die, it screamed. It flapped, it ran in circles. Any reasonable person would stop here. Reassess, maybe call a professional, not our guy. Whack, 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 5-6 times per chicken, and they still wouldn't die properly. These poor birds were staggering around like feathered zombies, making sounds that would haunt those children's dreams for years. But wait, it gets worse. When a chicken proved particularly resilient to his hammer-based murder system, he'd just give up, toss the half-dead bird aside like a broken toy and grab another one. Soon the farm looked like a poultry horror movie. Chickens dragging broken wings, chickens walking in stuttering, brain-damaged circles, chickens screaming in ways the children didn't know chickens could scream. One brave student pulled out a phone and recorded it. The video was like something from a found-footage horror film, complete with children crying in the background and teachers trying desperately to herd kids away from the scene. 23 chickens, 23 separate attempts at hammer-based euthanasia. 0 successful quick deaths, 100% pure trauma for everyone involved. When confronted by the principal, the farm manager asked defense was spectacular. This is how my grandpa did it. Your grandfather was probably better at it. It asked traditional farming. This isn't a traditional farm, it asks an educational center. Kids need to know where food comes from, not like this, never like this. The school district fired him immediately. Their lawyer recommended they fire him yesterday, retroactively, if physics allowed. Maybe fire him before he was hired, create a time paradox if necessary. But then plot development, nobody expected he sued for wrongful termination. His claim, gender discrimination. Yes, gender discrimination. His theory, a female farm manager would never have been fired for traditional farming practices. The lawsuit actually claimed that his masculine approach to chicken euthanasia was being unfairly targeted. My client was fired for being a man who kills chickens like a man. His lawyer argued, presumably while dying inside, your client was fired for traumatizing children and torturing animals. I responded, that ass sexist, that ass. What? How? You saying a woman would kill chickens better? I'm saying anyone would kill chickens better. A blindfolded toddler with safety scissors would kill chickens better. The judge threw out the case so fast it might have achieved escape velocity. The farm manager's lawyer later apologized to me in the parking lot, muttering something about client insisted and I need a drink. The farm now has a strict policy, no animal euthanasia during school hours. If an animal needs to be put down, a licensed veterinarian is called. The hammer has been removed from the property. They probably buried it at sea, just to be safe. The children received counseling. The chickens received proper burial. The farm manager received a new career in something that hopefully doesn't involve animals, children, or hammers. And somewhere, his grandfather's ghost is probably wondering how someone could fail so spectacularly at something so simple. Story 3. The judge who kept it real. Judicial recusal is serious business. Judges are supposed to be impartial arbiters of justice, removed from personal bias or prejudice. They were expected to step aside with dignity and professional reasoning when conflicts arise. This judge said screw that and chose violence. The case seemed routine. Criminal defendant, standard charges, typical Tuesday in the courthouse. Until the judge looked at the case file, looked at the defendant, and presumably felt years of suppressed honesty bubble to the surface. I am recusing myself from this case, he announced. Normal so far. Judges recuse themselves all the time. Previous relationships, financial interests, knowing the parties involved, standard stuff. The reason for my recusal, he continued, as the court reporter's fingers hovered in anticipation, is that I know the defendant personally. Still normal. Happens frequently in smaller jurisdictions, and I know for a fact that he is a son of a bitch who is guilty as hell. Record scratch, freeze frame. The court reporter looked up, wondering if she'd heard correctly. The bailiff's hand instinctively moved toward his radio. The defense attorney's mouth opened and closed like a fish discovering air isn't breathable. The judge wasn't done. 20 years of judicial restraint had finally snapped like an overstretched rubber band. I've known this man for 15 years. He has been in my courtroom 8 times. He is guilty every time. He was probably guilty of stuff we didn't even charge him with. I wouldn't trust him to watch a rock. The defendant, for his part, seemed almost proud. Like getting a judge to break protocol through sheer awfulness was an achievement worth putting on a resume. Your Honor, the defense attorney managed. Perhaps we could seal these comments. Seal nothing. Let the record reflect that Defendant Johnson is a career criminal, a liar, and the reason I drink. I am recusing myself before I sentence him to something unconstitutional out of pure personal satisfaction. The prosecutor didn't know whether to object or applaud. The defense attorney was calculating how many different appeals this created. The court reporter was typing furiously, probably wondering if she should censor any of this. Furthermore, the judge continued, now fully committed to burning every bridge. Whoever gets this case should know that his alibis are always his cousin Ray, who'll say anything for $20 and a pack of cigarettes. His character witnesses are other people he hasn't screwed over yet. And that face he makes, like he is confused, he is not confused. He knows exactly what he did at this point. Court security was genuinely concerned the judge might leap over the bench and handle things personally. I've been a judge for 20 years, he concluded. I've seen thousands of defendants. I pride myself on impartiality, but this man tests the limits of human patience. I am recusing myself for his safety, not mine. He stood up, black robes billowing dramatically. Good luck to whatever poor bastard gets this case, you'll need it. The defendant asks guilty, his lawyer knows it, hell, even his mother knows it. She told me at the grocery store, his own mother. With that, he laughed, just walked out, left everyone sitting there in stunned silence. The case was reassigned to another judge who apparently heard about the incident. During the trial, whenever the defendant made his confused face, the new judge would visibly suppress a smile. The defendant was convicted, shocking absolutely no one, especially not the first judge, who was probably somewhere raising a glass to the inevitable outcome. The recusal made legal history as the most honest statement of bias ever recorded. Law students study it as an example of what not to do, while secretly admiring the sheer honesty. And somewhere, that judge is probably still encountering the defendant at the grocery store, shaking his head and muttering guilty as hell under his breath. Some bridges are worth burning, especially if you torch them with style. Story 4. The MySpace dancer asked downfall. Back in the mystical era of MySpace, when everyone had a top 8 in profile songs assaulted visitors' ears, a woman made the fatal mistake of forgetting the internet is forever. She'd been hit by a big rig in foggy weather, serious accident. Claims of debilitating back injuries, lawsuit filed, big money on the line. Her lawyer probably already had the victory, champagne on ice. The trial progressed smoothly. Medical testimony, witness accounts, the woman herself, testifying about her chronic pain, limited mobility, and how the accident had destroyed her quality of life. The jury was sympathetic. Who wouldn't he be? David versus Goliath. Injured woman versus trucking company. Then came the final day of trial. The defense attorney stood up with the energy of someone holding for aces and a royal flush as backup. Ma'am, do you have a MySpace account? The woman froze. In that moment, she knew. She knew exactly what was coming. Her lawyer's face went through the 5 stages of grief in about 3 seconds. Yes, may we show the jury your profile? Objection. Her lawyer cried, though you could hear the defeat in his voice. Overruled. Up on the screen came her MySpace page, glittering graphics, animated butterflies, an Avenged Sevenfold song automatically playing. And there, in full photographic glory, a picture of her dancing. Not just dancing. On the hood of a car, in heels, back arched like a professional limbo champion. Dated 2 weeks after the life-altering accident, the courtroom fell silent except for the tinny sound of her profile song playing through the court-ass speakers. Even the bailiff was trying not to laugh, but wait, there ass more. Next to the photo, in the comments section, was a text exchange that would make any lawyer weep. Friend, girl, you killed it last night. That backflip was insane. Her, thanks babe. Just don't tell anyone. My lawyer says I need to look injured. Lol indeed. The defense attorney let that sit on screen for a full 30 seconds. You could actually hear her case dying. Ms. Johnson, the defense attorney said, voice dripping with false concern, this appears to be you doing a backflip on a car hood. Can you explain how this is consistent with your testimony about being unable to bend over to tie your shoes? That ass not a backflip, it ass a medical stretch. A medical stretch on a car hood, in 6-inch heels, at what appears to be a nightclub parking lot at 2 a.m. My doctor recommended it. Her own lawyer put his head in his hands. Some lies are so bad they cause physical pain to everyone in earshot. The defense wasn't done. They'd done their homework, screenshots of status updates. Killed it at Zumba today. Who's ready for Vegas? Got my dancing shoes? That moment when you forget you were supposed to be injured and accidentally do a cartwheel and target that last one. That last one was the kill shot. She literally posted about forgetting to fake her injury. The jury deliberated for 12 minutes. 11 of those were probably just them walking to the room and figuring out who wanted coffee. Verdict: complete defense victory. 0 damages. Case dismissed with prejudice. The woman tried to delete her MySpace on her phone during closing arguments. The judge saw her and actually said, "Ma'am, we already have screenshots. Please stop." Her lawyer probably went home and created the first social media for idiots seminar for clients. Rule 1. If you claiming you can walk, don't post videos of yourself winning dance battles. This case became legendary in legal circles as the moment lawyers realized social media would be their best friend and worst enemy. Discovery requests now always include all social media profiles, including but not limited to MySpace, Facebook, and whatever the kids are using these days. The defense attorney framed a screenshot of the car hood dancing photo. It hangs in his office under a plaque reading, "Thanks for the easy win, Tom." Yes, Tom. Her MySpace profile was Tom as friend, and Tom was everyone as friend, including the defense team as investigator. MySpace, bringing people together and destroying personal injury lawsuits, mostly the second thing. Story 5, the ineffective inception theory. Court of Appeals is where serious lawyers make serious arguments about serious legal issues, constitutional questions, precedent-setting cases, and occasionally unintentional performance art. An attorney stood before 3 circuit judges, ready to argue that his client deserved a new trial due to ineffective assistance of counsel. For non-lawyers, this means your previous lawyer was so bad it violated your constitutional right to adequate representation. Your Honors, he began, shuffling papers with the coordination of a caffeinated squirrel, my client's previous attorney provided representation so deficient, it shocked the conscience. Strong opening, the judges leaned forward, ready to hear about this travesty of justice. Then things went downhill faster than a shopping cart with a broken wheel. The attorney couldn't find his notes. He cited the wrong case law. At one point, he argued something that actually hurt his client's position. He confused the facts of his case with what appeared to be an entirely different case, possibly from a different jurisdiction, possibly from a different century. "Counselor," one judge interrupted, "you citing a maritime law case. This is about armed robbery, is it?" The attorney asked, genuinely confused. "Yes, your client robbed a convenience store, not a ship. The principles still apply." "No, they don't." The attorney pressed on, each argument worse than the last. He misquoted his own brief. He forgot his client's name twice, calling him the defendant, and once, memorably, Steve. His client's name was not Steve. The judges exchanged glances, the kind of glances that write themselves into legal legend. Finally, the center judge, a woman known for her patience and professionalism, leaned forward. The courtroom held its breath. "Counselor," she said, words measured like medicine, "are you currently providing ineffective assistance of counsel?" The silence that followed was so perfect, so complete, that it probably violated the laws of physics. Somewhere, a philosopher felt a disturbance in the concept of irony itself. The attorney's mouth opened, closed, opened again. His brain had encountered a logical paradox and responded by freezing like Windows 95. Because here's the beautiful trap. If he said yes, he was admitting to being incompetent, potentially giving his client grounds for yet another appeal. If he said no, he was undermining his entire argument that bad lawyering justified a new trial. Your Honor, that ass." The judge waited. Everyone waited. Time itself seemed curious about how this would resolve. "I believe I am providing zealous advocacy within the bounds of that wasn't the question." More silence. The court reporter looked up, fingers poised, ready to transcribe whatever came next for posterity. The attorney chose the bold strategy of pretending the question hadn't been asked. He launched back into his argument, which somehow got worse. He claimed ineffective assistance based on his previous lawyer's failure to investigate alibi witnesses. When asked who these witnesses were, he couldn't remember. "They were in the file, your file, my client's previous lawyer's file, which you've had for 6 months. I've been very busy." At this point, the prosecution didn't even need to respond. They just stood there, occasionally nodding, like watching a fire that was putting itself out. The attorney concluded by arguing the wrong legal standard, asking for the wrong relief, and thanking the wrong judge. It was performance art masquerading as legal advocacy. The judges retired to deliberate. They probably spent most of it laughing. Appeal denied, obviously, though they were probably tempted to grant it just to see what would happen at the next level of ineffectiveness. The kicker: the attorney later tried to use this case as an example of the appellate court's bias against criminal defendants. He seemed genuinely confused why judges wouldn't take seriously an argument about incompetent lawyering made by a lawyer actively demonstrating incompetence. It asked like rain on your wedding day, if Rain was an attorney arguing he is not currently drowning while standing in a flood of his own making. The case is now taught in law schools under the title How to Prove Your Own Point in the Worst Possible Way. Students love it, professors use it as a warning, and somewhere, that attorney is probably still practicing, still confusing maritime law with armed robbery, still providing live demonstrations of his own arguments. The legal system, where irony goes to law school and graduates with honors. Story 6. The seasoned judge's revenge. Timing is everything in comedy. Also in career-ending legal statements, a defense attorney stood before the court, chest puffed with confidence, ready to deliver what he thought was a masterful argument. His client sat beside him, probably already counting his winnings. Your Honor, the attorney began, the evidence against my client is so thin, so circumstantial, that frankly, I am surprised we even hear standard defense posturing. The judge nodded, taking notes. In fact, the attorney continued, building momentum like a train heading toward a cliff. I believe a more seasoned judge wouldn't have let this trial move forward. The words hung in the air like a fart in an elevator. The prosecutor's eyes widened. The court reporter's fingers froze. Even the defendant seemed to realize something had gone catastrophically wrong. Because here's the thing about judges, they have memories, and this particular judge had an excellent memory. She looked up slowly, the kind of slowly that suggests you've made a terrible mistake but haven't realized it yet. Counselor, she said, voice like honey over broken glass, are you aware of who approved this case to move forward to trial? The attorney's confidence flickered like a candle in a hurricane. Well, I assume you assume. How refreshing. I approve this case for trial. Me, this unseasoned judge you addressing. The attorney's face went through several shades of pale before settling on ghostly. I didn't mean oh, but you did. You meant that a more seasoned judge, someone with more experience than my 23 years on the bench, would have thrown out this case. Tell me, counselor, how many years have you been practicing? 7 years. And you lecturing me on judicial experience. The prosecutor was trying not to smile. The defendant was trying not to fire his lawyer mid-trial. The court reporter was typing furiously, knowing this was going into the Hall of Fame. Your Honor, I misspoke, did you? Or did you simply not do your homework? Because a seasoned attorney might have checked who made the preliminary rulings in this case. The attorney attempted damage control, but once you've called a judge incompetent to her face, especially when that judge was the one whose decision you criticizing, there's no coming back. Motion to dismiss, the judge asked, voice dripping with sarcasm. On the grounds that I am not seasoned enough to recognize a valid case. That not motion denied. Enthusiastically denied. Denied with prejudice. Denied so hard your future motions feel it. The attorney slumped in his chair. His client leaned over and whispered something that probably wasn't a good job. The trial proceeded. Every objection from the defense was met with "I consider that, though I am not sure I am seasoned enough to rule correctly." Every motion was prefaced with, well, let us see what this unseasoned judge thinks. By day 3, the attorney was begging for mercy. Your Honor, I sincerely apologize for my earlier statement. Oh, now you think I am seasoned enough to accept your apology. The jury found the defendant guilty on all counts. During sentencing, the judge made sure to note her extensive experience in criminal law, her years of precedent-setting decisions, and her absolute certainty that this case was properly brought to trial. The attorney's closing argument was 12 minutes of legal reasoning and 45 seconds of barely concealed groveling. It didn't help. Word spread through the legal community faster than gossip in a small town. The attorney became known as Seasoning Boy. Other judges would ask him if they were experienced enough to hear his cases. Court clerks would offer him salt and pepper with his motions. He eventually moved to another jurisdiction. Legend says he researches every judge's career history before speaking. Checks who made every preliminary ruling. Possibly has flashbacks when he sees Spice Rex. The lesson, know your audience, especially when your audience has the power to make your professional life a living hell seasoned with regret. The lesson, know your audience, especially when your audience has the power to make your professional life a living hell seasoned with regret. Story 7, the Twitter boob job trial. 3 years, 3 years of litigation, depositions, expert witnesses, and medical testimony. All about to be destroyed by the most powerful legal weapon of the 21st century, a patient's Twitter addiction. The plaintiff sat in court, dabbing her eyes with tissues, describing how her botched breast augmentation had left her too traumatized to leave her house, too self-conscious to socialize, too damaged to live a normal life. I can't even go to the grocery store, she testified, voice quavering. The way people look at me, I know they ray judging. I haven't been out socially in months. The jury was sympathetic, the judge was attentive, her lawyer was probably calculating his contingency fee. Everything was going perfectly, then the defense attorney stood up. There has a specific energy when a lawyer knows they ray about to destroy someone. It has like watching a cat play with a mouse, except the cat went to law school and the mouse posted her own demise on social media. Mrs. Davidson, he began, you say you haven't been out socially. That as correct? I am too self-conscious to leave the house. Yes, I see, Your Honor, I'd like to present exhibits 1 through 247. The plaintiff's lawyer's face went white. The plaintiff herself looked confused. What could possibly require 247 exhibits? Twitter, that ass what? The defense attorney had printed every single tweet she'd posted since the surgery. Every single one, and now he was going to read them out loud. To the jury, let us start with March 15, 2 weeks post-surgery. You tweeted, and I quote, killed it at ladies' night, these new girls were bouncing on the dance floor. Blessed and breasted the plaintiff sank lower in her chair. April to ND, beach day, rocking this bikini like never before. Thank you Drive, Mitchell for the confidence boost. Beach babe new record as her lawyer stood up. Objection, relevance. Your client claims she can't leave the house due to trauma from the surgery. I am demonstrating she is quite social, overruled, continue. And continue he did. For 2 excruciating hours, April 18 got so many free drinks last night. Bartender cold and stop staring, these babies are paying for themselves. Investment pieces. The court reporter was struggling to maintain professional composure. One juror was covering his mouth to hide laughter. The judge appeared to be seriously reconsidering her career choices. But the defense attorney wasn't done. He brought visual aids. Blown up photos from her Instagram, which she helpfully linked to her Twitter. Is this you in Aruba, May 5 I. Maybe, in a string bikini, it was a family trip. The caption reads single and ready to mingle with these new additions. Hot girl summer thank Yowder Mitchell. Each exhibit was worse than the last. Photos at clubs, beach volleyball tournaments, a wet t-shirt contest she placed second, all posted publicly. All hashtagged enthusiastically, all completely destroying her claim of being a traumatized shut-in. The judge called for a break. The plaintiff ran out crying real tears this time. 20 minutes later, her lawyer returned the line. Your Honor, my client wishes to withdraw her complaint. I am shocked, the judge replied, voice drier than a martini in the Sahara. The defense attorney wasn't even smug about it. He just calmly packed up his remaining 150 exhibits, including what appeared to be printouts from a Rate My Rec website where the plaintiff had posted asking for feedback. The reviews were positive. 3 years of litigation, probably hundreds of thousands in legal fees. All undone because someone couldn't resist humble bragging about their surgical results on social media while simultaneously claiming those same results ruined their life. The case became required reading in legal ethics courses as why you need to check your client as social media. It has also exhibited in things to tell your lawyer before trial. The plaintiff deleted her Twitter that afternoon, too late. The internet is forever, and so is legal precedent. Her final tweet, posted minutes before deactivating, sometimes the truth isn't what matters in court. Corrupted Justice Forsell. The defense attorney screenshotted that too. Just in case. Story 8. The judicial recognition paradox. Sometimes the universe aligns to create moments of perfect comedic timing. This was one of those moments, served with a side of judicial awkwardness. Judge received an unusual request. Judge B needed someone to handle a bond reduction hearing because Judge B had previously represented the opposing party against this defendant. Conflict of interest happens all the time. Judge A pulled up the case file, glanced at the mugshot, and started laughing. Not chuckling, full-throated, tears in eyes left her. I need to call Judge B, she managed between gasps. The phone call that followed would become courthouse legend. Hey, you need me to handle the Johnson bond hearing because you represented the victim. Yeah, I was his lawyer 5 years ago. Can't he be impartial? Funny thing about that. What? I was Johnson's lawyer in that case. Silence. Then Judge B started laughing too. 2 judges, same case. Opposite sides, now both unable to hear the current case because they both previously wanted to strangle the specific defendant, albeit for different reasons. He asked back already, Judge B asked. Armed robbery this time, of course. Was it at least creative? He tried to rob a gun store. A gun store, with a knife, a butter knife, more laughter, the kind of laughter that comes from years of dealing with the criminally stupid. Remember what an asshole he was during depositions, Judge A reminisced. Remember, I still have nightmares. He tried to argue that stealing wasn't theft if you really needed the money. Didn't he? He also claimed the victim assaulted him by existing in the store he was robbing, yes. And his alibi was his mom, who was in jail at the time. For robbing the same store, they spent 20 minutes sharing war stories about this defendant. How he filed complaints against both of them for inadequate representation and excessive prosecution. How he tried to fire a judge mid-trial for not believing in his innocence hard enough. How he accused Judge B of being part of a conspiracy between prosecutors and store owners. So we need a third judge, Judge A concluded, someone who hasn't had the Johnson experience. Does such a judge exist? They found Judge C, a newer judge who somehow avoided this particular defendant. They warned him, he asked going to claim the system is rigged against him. It kind of is, Judge C noted. The judges had to recuse themselves because he is professionally memorable for all the wrong reasons. During the bond hearing, the defendant recognized both judges in the gallery they'd come to watch. His eyes lit up. Your Honor, he shouted at Judge C, this is a setup. Those two are here to influence you. They biased against me, sir. They not part of this hearing. They represented me and prosecuted me. Now they both judges. This is a conspiracy.